That's the law. All
Okay,
right.
sir.
So
So, but
learn to live with it.
that's
Mm-hmm.
that's a clear abuse of power. I've been up here for 150 days, and I've asked my clients, or not my clients, my attorneys, to please represent me in this matter, and they have not done it. And they can't give me a reason. They can't give me a KSA. They can't give me any of that. I've been up here for 150. This is an abusive process.
If you don't like it, go hire your own lawyer. Okay? That's your choice.
No, I'm not asking that. I'm not asking them to
No,
withdraw.
no,
I'm
I'm
asking you
done.
to rule
I
on the
am
procedural
denying the
timeline.
motion to withdraw,
Will you
and I
rule on the
appreciate.
procedural timeline error?
Okay. Jailer, put him on mute.
I can assure you that he is one of the most obnoxious defendants you will ever see. This whining kid is in court today. The judge isn't putting up with him treating his own lawyers with such disdain. He is being charged with the most unimaginable crime, which is the death of his 5-month-old daughter. Prosecutors also claim that she had dangerous drugs in her bloodstream. He is currently being charged with second-degree murder, which is a very serious offense. While we watch, let me know, is the judge entirely correct to dismiss this man, or do you think he has a point? Let's jump in and observe.
Your Honor, Mr. Leon appears by Zoom and through counsel, Christopher A. Rourke Colby and Cassie Ziegler of Ellis County.
All right, Mr. Leon, do you have any objection to us conducting this hearing by Zoom?
No.
Very good. This before the court on the defense counsel's motions to withdraw. Those were recently filed as actually yesterday, and both counsel asked for an emergency hearing or as early as possible. Mr. Leon, are you ready to proceed on your counsel's motions to withdraw?
I am, sir. And then I'd like to address the courts if that's okay.
Well, we'll see. Let's get to the motions first with the attorneys. Besides what's in the motion, is there anything additional that either attorney wants to present?
Your Honor, I think that the only thing, anything additional I present, I think given Mr. Leon's, I think, behavior, demands, threats, his actions, going through with those threats, I think the trust between the attorney and client's broken, and I don't know how you fix that.
Okay. Ms. Ziegler, anything additional besides what Mr. Rohr said?
No, I totally agree with Mr. Rohr, and I don't think I have anything else, Your Honor.
Okay. Ms. Leon, I will now invite your comment. Leave it strictly to this motion to withdraw. Nothing else about the case, because that's not what's before us today. You understand?
Yes, sir. I do have. Yes, sir. So,
okay. Regarding the motion to withdraw, do you wish for these two attorneys to withdraw?
So I have asked my attorneys to file a motion multiple times on a procedural timeline error of not having me into a preliminary hearing within 14 days. This right is guaranteed to me per the state statute 7.2 and supported by my 4th Amendment right to due process and incorporated by my 14th Amendment due process clause. State versus Fink does guarantee the defendant the right to be within a preliminary hearing within 14 days. And I've asked them both to file these motions. Neither one of them are filing these motions. And I would ask the court to consider these motions as well as, I haven't asked them to withdraw. They said I've just asked them simply to do something. Your Honor has already ruled on this and told me that he was not going to allow them to withdraw because of the state's short amount of attorneys that can handle these cases. So I have not asked them to withdraw at all. I've simply asked them to invoke and enforce or ask the courts to enforce my right to due process in my 14th Amendment due process clause because there is a procedural timeline error, and they continue to try to dissuade me from bringing this to your attention, saying that it's not correct. But I have the state statute pages right out of the book that an attorney has sent in that does guarantee me these, says that it does guarantee me the right. While it's not, preliminary is not, like mandated, it's not constitutional. But in that case, I would then need to be to an arraignment within 10 days. I've not waived that right. And my attorneys of counsel, my attorneys, I've brought this up to them multiple times. Cassie, hung up on me once when I was trying to talk to her about it. Mr. Rohr has said that he was going to bring the issue up to you, and then next thing I know, he was telling me that next thing I know, I'm getting a motion saying that you guys are going to withdraw. They're trying to withdraw counsel. I didn't ask them to withdraw. I took your ruling on the matter last time seriously, is that you were not going to let them withdraw. I'm not asking that they withdraw. I'm asking that they represent me to their fullest of capabilities in this matter of my the procedural timeline.
Okay.
Sounds like you're talking about a defendant who's in serious trouble, yet acting like is the star attorney on the case. Here's your passage rewritten with a fresh spin while keeping the meaning intact. This guy's facing one of the most serious cases imaginable, yet he's clinging to anything that might give him a shred of hope. He's got two highly competent lawyers right beside him, but you'd swear he thinks he's the one running the defense. The way he talks, you'd think he's been in the legal profession for decades. My guess, he knows the pile of evidence against him is overwhelming, so he's tossing out every argument he can, hoping one might somehow stick. That's what desperation looks like. But there's a difference between having a legal strategy and completely disregarding the advice of the people literally fighting to keep you out of prison. He keeps interrupting and speaking over his attorneys in court, which not only plays badly in front of the judge, but also hurts his own credibility. Public defenders aren't flawless, but they still understand the legal system far better than almost any defendant ever will. The more he talks, the clearer it becomes. He's either deep in denial or truly convinced he's the smartest person in the room. So the question is he just flailing at this point, or does he genuinely believe he's the legal mastermind here?
So, Mr. Leon, your basic argument with your attorneys right now is that you want them to file a motion to dismiss your cases for failure to bring you to preliminary hearing within 14 days, correct?
That and there are other matters, sir.
Okay. Well, that's what you started with. Let's just begin.
Okay.
All right.
Okay.
Your attorneys both know the law. Now, you've noted the statute, 222902, okay? But they also know the law. State versus Weigel, the Kansas Supreme Court ruled in 1980, quote, the time limitations in 222902 are directory and an inconsequential delay beyond the time specified for holding a preliminary hearing will not justify dismissal. That is the law in the state of Kansas. It has been the law since 1980. It has not changed. And so your attorneys are aware of that, as is the court and the prosecutor. They do not have an obligation to file frivolous motions. And so your argument with them is that they won't do what you direct them to do, and that is not their responsibility. I explained this to you before. How an attorney handles a case, the strategy is their decision, not yours. You have input. They will listen to you. They will incorporate your thoughts, but they will do what they believe is in your best interest under the law. They are not there to do what you tell them to do. Rather, they're there to represent you zealously and as advocates within the ethical boundaries that are set there. That's the rule. So you can sure tell them, I would like you to file this motion because I think it's a violation. And they would say, well, we understand you read it that way, but it's already been in front of the Kansas Supreme Court and they disagree with you. And that's the highest authority in this state. So,
but Your Honor, State versus Fink says that I have this. Hold on.
Yeah, I'm telling you, Mr. Young, I'm not going to have a legal debate with you. Okay, I'm telling you, I gave you the case citation. It is not the only Kansas Supreme Court case that is ruled on this issue. It is directory, not mandatory.
I understand that, sir. I've been up here for 150 days without a preliminary hearing or any type of court proceeding. That's a clear abuse of power.
Well, that's a different argument, and we're not going to. I told you we weren't going to get into that. We're here to talk about whether I'm going to let your attorneys withdraw or not. Okay, but I wanted to give you at least the law to explain why they don't do everything you ask them to do.
Your Honor, that doesn't tell me anything about the procedural timeline error, though, that I've been asking them to represent me on. The procedural timeline error does say, Your Honor, that an abusive process cannot be done. I've been up here for 150 days, and I've asked my clients to please represent me in this, or not my clients, my attorneys to please represent me in this matter, and they have not done it. And they can't give me a reason. They can't give me a KSA. They can't give me any of that. And it also says, Your Honor, that I am entitled to being into a preliminary hearing or an arraignment within 10 days. I've been up here for 150. This is an abusive process.
Okay. I've listened to this before. This is what we're here for today, is your attorney's request to withdraw. Here's what the court's going to hold. You can keep filing ethical complaints on them. You can keep doing whatever, all of these pro se filings. I mean, you have a lot of time on your hands up in jail. So I'm not in any way telling you that you're prohibited from doing that, but they will control the strategy and the procedure in their representation of you. And here's the bottom line, Mr. Leon. I could appoint every attorney in the state, and they're going to have the same problem with you that these two attorneys do. That's the criteria I have to look at. Okay. If you don't like it, go hire your own lawyer. Okay. That's your choice.
The judge can see straight through what this guy is trying to do, and it's not landing. He keeps waving around state versus Fink like it's some magic get-out-of-jail card, but it doesn't trump Supreme Court precedent. Yes, he's been in custody for 150 days without a preliminary hearing, but there's a reason. Serious felony cases, especially ones involving the death of a child, often take months to prepare. There's evidence to review, witnesses to coordinate, and schedules to manage. When you're staring down decades behind bars for something this serious, you don't exactly get to cut the line for a speedy release. Yet is acting like the system owes him an express pass out of custody. Instead of using this time to work with his attorneys, he's busy fighting them at every turn. Public defenders are one of the most vital safeguards in the justice system. They give people without money a fighting chance. And here we have someone openly disrespecting that lifeline. The court's patience has limits, and every time he pushes, he edges closer to burning every bridge he has. This is what happens when ego takes the wheel and strategy gets left in the dust. The question is, does he have any idea how badly he's hurting himself? Or is he too busy trying to be right to notice the damage?
But if you can't hire a lawyer and you apply to the court, you're going to live with and deal with the competent and qualified lawyers that the court appoints for you. That's the law. All right.
Okay, sir.
So learn to live with it and learn to cooperate with them, because I'm not going to let them withdraw, because if I do, the next lawyer I appoint, I'm going to have the same argument. And here's the other thing, Mr. Leon. Your main argument is, Judge, I've been up here 150 days. I want my day in court. If I appoint a new lawyer, they're going to have to review all of the discovery in this case. They're going to have to interview witnesses. They're going to have to communicate with the prosecutor. They're going to have to visit with you. That takes time. And that you're not the only client they have. So that time is longer. So the very thing you're complaining about, if I grant the request that they're making on your behalf today, only increases that very time standard. The very key problem you're talking about. It's counterproductive.
I understand that. I'm not asking that. I'm not asking them.
No, well, I'm done. I am denying the motion to withdraw at this time.
Will you go on the procedural timeline, Aaron?
Okay. Jailer?
Yes, sir.
Put him on mute. I'm not going to have him interrupt me anymore. Thank you. Counsel, I just wanted to express to you that I appreciate the dilemma you have. It's not the first time you have gone through something like this. I'm denying your motions at this time for the reasons I recited. Number one, any other lawyer I appoint is going to have the exact same problem. I'm just going to keep repeating it. And number two, if I appoint new counsel, it's going to further delay the hearing, and we already have a preliminary hearing scheduled. And I'm not going to delay it another 100 days or 150 while a new attorney gets up to speed on the case. This defendant's complaining that he wants to get into court. We're going to give him that because it's scheduled, and we're going to go forward with it as scheduled. Understood?
Yes, sir.
Yes, sir.
Very good. Okay. Anything else that you need to address with the court today?
No, you're understanding.
Very good. All right. We are scheduled for preliminary. When is that again?
Next week.
Next
Wednesday,
week.
The 14th, 13th. It's the 13th.
Yeah, I knew it was coming up. I knew it was next week sometime. Let me look here. Yeah, we're scheduled for an all-day preliminary next week, Wednesday, a week from today. So, since Mr. Leon's main complaint is, I want to get my preliminary, we're just going to get it a week from today. And if we hire or if we appoint new counsel, it would be delayed probably well into January or February next year with the holidays and the scheduling problems. So we will give him what he wants. I will expect that you will visit with Mr. Leon about his conduct in the courtroom. In other words, that he's not to interrupt either the judge or witnesses, that he's to listen to the evidence, that if he needs a recess to visit with you, the court will accommodate that and allow you to go into chamber or into the conference room to do that. I know he's listening to this, and I'm hoping he's paying attention, because I will not tolerate the kind of conduct that we had exhibited today, where he continually interrupts and continues to repeat the same arguments. So he's going to get a preliminary hearing as he desires, and it is a week from today. And with that, we will be adjourned.
Thank you, Your Honor.
Thank you.
Honestly, I can't figure out why this guy's even complaining. My guess, he's just stalling for time because he's terrified of ending up in prison. The irony is, prison would probably be an upgrade from county jail. Better living conditions, more programs, and fewer constant lockdowns. But let's be real, he's facing an unthinkable charge: the death of his 5-month-old daughter while she was under his care. Prosecutors claim they found dangerous substances in her system. That's not the kind of accusation you just walk away from. At this point, you don't get to nitpick the process. You deal with what's coming. If it were my call, someone like this would never step foot outside a cell again. So what do you think? Is he just scrambling for any delay he can get, or does he genuinely believe his own lawyers are somehow working against him? Thanks for watching. I appreciate you all. Don't forget to like, subscribe, and I'll see you in the next one.